Good morning. Welcome to our annual training regarding municipal securities disclosure. We'd like to thank all of you for joining us for the program. As we move throughout the program, we would encourage you, as questions arise, to please email them to smith.james@dorsey.com. James Smith is going to be monitoring his emails throughout the program, and again, you can submit your questions to smith.james@dorsey.com. My name's John Danos, a proud member of the public finance team here in Des Moines for Dorsey and Whitney law firm, joined this morning by my partner James Smith and our colleague Brian Damman. You'll hear all three of our voices at different times throughout the program. As we move into our discussion of regulatory issues for municipal securities disclosure, I wanted to cover a few glossary terms that may help you if you're not as familiar with this landscape. These are terms that we'll use fairly loosely during the program because they're second nature to us, so we wanted to talk about them with you. First, when we say an issuer of bonds, for your purposes, mostly that's going to be your city, county, school district, the governmental entity that issues the bonds. Sometimes you'll hear us use the term financial advisor. More accurately, in the modern world, a municipal advisor. This is a consultant or financial advisor who provides, as the name would suggest, financial advice to an issuer of bonds, sometimes with respect to a debt issue, sometimes with respect to budgetary and other revenue-related matters. You'll hear us talk about underwriters or investment bankers. These are financial institutions out there in the world that ply their trade purchasing bond issues and then reselling them into the bond market. So when you hear us talk about an underwriter or investment banker, that's an initial purchaser of the bonds who will then resell to the bond market. Our friends at the SEC, that's the Federal Securities and Exchange Commission, are charged, among other things, with providing regulatory oversight of the municipal bond market to certain degrees, and we'll be talking today about those degrees. When you hear us use the letters OS or POS, that's us referring to an official statement or preliminary official statement. This is the offering document, or as I like to put it casually, the advertising circular that will be put together anytime an issuer is trying to issue bonds out into the municipal bond market. More alphabet soup, CDC. This is a continuing disclosure certificate. It is a document that any issuer of bonds going to the municipal bond market will be required to adopt, so long as the particular issuance of bonds is at or over $1 million in principal volume. You'll hear us talk about EMMA, the Electronic Municipal Market Access. This is a website and filing repository for financial data and disclosure items for all bond market issues by all issuers participating in that market. We'll talk more about that. It's critical. And finally, in terms of terms to help you with, you'll hear us refer to a dissemination agent and to dissemination agent agreements. Dissemination agents are hired professionals who can assist an issuer of bonds with doing the required continuing disclosure obligations that the issuer may face in connection with a bond issue. And the agreement is simply the contract that runs between the issuer and that agent, covering what the respective parties' responsibilities will be. We have certain objectives that we'd like to meet. We hope we meet them for you today with respect to this program. First, we hope that you'll gain a better understanding of your issuer's responsibilities after your bonds are issued out into the market, and we hope you'll get some pointers on how to help manage those responsibilities. Well, how are we going to get there? We're going to try to provide a brief overview of the regulatory oversight and applicable rules that your issuer faces in this arena of disclosure and continuing disclosure for municipal bond issues. We're going to run through in brief and review the contents of a continuing disclosure certificate and disclosure policy, which is a document that we are encouraging more and more issuers to get adopted and to have on file to help manage these ongoing regulatory issues. And finally, we're going to provide some discussion of how practically to go about complying with disclosure requirements. Why do we worry about disclosure at all? What's its purpose? Well, from sort of a crass standpoint, because we have to, the regulators tell us that we must. But in addition to that, we worry about it because it, in essence, is the right thing to do. The SEC certainly wants issuers of bonds to provide ongoing information about the bond issues or debt issues that we put out into the market. When we talk about disclosure, I want you to keep in mind we have two phases of disclosure on every deal. We have the pre-sale of bonds phase of disclosure. That's when you're first issuing the bonds out into the market. That's where your official statement and preliminary official statement are so important. And then we have a second phase, continuing disclosure, that keeps on going as long as those bonds are out in the market. These areas of disclosure help to provide transparency for investors out in the public who are participating in the bond market. We've got to remember, Granny Smith in Fort Lauderdale, Florida might be buying, selling, and trading City of Fort Dodge bonds today, or whatever town you're from, or school district you're from, or county. Your bonds that are out in the bond market are being bought, sold, traded. And so one of the purposes for disclosure is to give that public, Granny Smith, if you will, participating in the bond market, access to information so that they can make informed investment choices. Also, disclosure ensures that bonds sold to investors on the secondary market are being properly priced based on the information that's being provided to the issuers. These pricing elements are very important to the regulators, to the IRS, et cetera. So we're not only protecting the public, we're also protecting, in a sense, the larger system. Now, where does the SEC get its authority from? Under federal law, issuers are subject to anti-fraud provisions of federal securities regulations. And those are big words, anti-fraud. It should go without saying to all of us, we are not allowed to be fraudulent with our bond issues and with the information that we communicate to the public. but ultimately that is what the SEC is on the lookout for. And more particularly, the SEC has regulatory authority over the underwriters, those investment bankers I introduced you to earlier, through a rule 15C212 under the Securities Exchange Act of 1934. And the SEC exercises even broader regulatory authority over those underwriters who owe a particular duty to investors in municipal bonds. There are two aspects of this rule 15C212 that can impact you. First, the rule prohibits an underwriter from purchasing or selling bonds without first determining that the issuer, the governmental entity, has agreed to provide ongoing disclosure of certain important information, particularly annual financial information about the local government and material event notices, and we'll talk about what material events are. This rule, number one, that's what drives those continuing disclosure certifications, or CDCs, that we referred to earlier. If you're not executing those at the local government level, the underwriter is not going to participate in helping to sell your bonds into the market. Secondly, the rule requires that the official statement include a description of any material non-compliance that the issuer has had in the 5-year window prior to the offering of the then current issuance of bonds. So if we've fallen down, if we've missed some filings, if there have been some glitches, we are required to be disclosing those under the rule to the municipal bond market at the time of offering the bonds for sale. Now, we've provided sort of a cover page here of a sample official statement, not really to have you study the particular details on this. This is a common look for a first page of an official statement. But just to maybe trigger your memory about the last time you saw a document like this in your own context. The official statement, as I oversimply put earlier, this is the advertising circular that gets put together and used to offer any particular municipal bond issue to investors in the municipal bond market. Pre-sale of bonds, before the bonds are sold, this is the information that investors should be able to turn to, and really the only source of information without conducting their own further study, to figure out the kind of risk or reward that they might face if they choose to invest in your issuer's bond issue. Well, who's responsible for this document? Well, first, keep this squarely in your mind. Your issuer is primarily responsible for the content of the official statement and any other disclosure documents that wind up being conveyed with respect to your bond issue. Primary responsibility is at the courthouse or city hall or district headquarters, regardless of which professional helped to prepare the document. An issuer does not discharge its disclosure obligations by simply hiring an outside gun to put the document together. It is your issuer's document. And as such, your issuer has an affirmative obligation to know and understand what's included in the official statement, including any operating and financial data that's being conveyed in the document. Executing an official statement without first reading the document to check whether it's accurate may be a reckless act and could subject not only the issuer, but the officials and employees of the issuer to liability and action by the SEC. Let's keep in mind who's responsible for governing your issuer. Well, it's going to be your school board or your city council or your board of supervisors or whatever governing body is given state law authority to oversee the activities of your particular entity. So when we talk about responsibility, you need to be aware the SEC has shown not only are they willing to bring liability down on the entity, the city of X or school district Y, but to also look at individual officers and elected officials and employees. So we all need to take these responsibilities seriously. We've seen through SEC enforcement action in a variety of settings. You'll see some detail on this slide. I'm not going to trouble you by reading the whole thing, but in jurisdictions from San Diego to Miami to small rural school districts in Indiana, and the list goes on, we have seen the SEC bringing enforcement actions not only against the entities, but also threatening action against members of the governing body and employees, officials and employees who are working on an issue. Well, a preliminary official statement gets prepared pre-sale, right? That's really the initial offering out to the bond market. And then once an underwriter is selected and the prices are fixed on the bonds and the rates are determined, then a final official statement is consummated. To satisfy Rule 15C212, a final official statement will typically include a reporting of any trouble that's been had in the previous 5 years with regulatory compliance. We've provided you with a couple of examples of how that language might shape up in a document. For your final official statement, if your issuer has not complied with continuing disclosure obligations on previous bond issues, but does make the statement shown on the previous slide, this could constitute a material misstatement and subject the issuer to an enforcement action under anti-fraud provisions of federal securities laws. So it is important to pay careful attention to this, and I would say more than anything, please be aware when we're making these statements and crafting these statements, you're communicating them to the investing public, but you are also communicating them directly to the regulators. And if there's potential liability associated with the statements, we highly recommend that you get your bond counsel or disclosure counsel involved in making those determinations and crafting the language before just blithely allowing them to be released out to the market. Now, we've also provided a sample continuing disclosure certificate. That's the CDC that I helped define for you earlier. Again, this is a first page to help trigger your memory. You've seen them or something very similar to them before if you've had bond issues out in the market. The continuing disclosure certificate is really set up to help structure the city's the issuer's ongoing obligation to provide data and information out to the municipal bond market while the bonds are outstanding. And as such, the document is really focused on two ongoing obligations of the issuer. First, the obligation to submit annual reports. Each year after your bonds are issued and before they mature finally, if your original debt issue was over $1 million, you will have some type of obligation to file a report every year. In the modern era, conveniently, that report goes to Emma, that website I introduced you to earlier. The content of the annual report will typically contain audited financial statements if your issuer is audited every year. If your issuer is small enough to not be audited every year, you're going to want to consult with your professionals involved with the bond deal, but for sure you're going to wind up posting your annual financial report to the state of Iowa, unaudited. In addition, you may be responsible, depending on your circumstances, for also updating some of the information that was originally contained in the POS, including things like valuation, or if you're doing a GO deal, it might be critical to focus on property tax related issues. If you're doing a revenue type deal, most of that data is going to be more focused on the utility or enterprise or proprietary system that you're securing the bonds with. So you'll need to be aware with every deal, in addition to the audited financial statements, what other information are you obligated to be updating every year? Make sure you understand that. That's the first aspect of continuing disclosure. The second is a focus on more real-time disclosure, where it's not once a year reporting, it's anytime these so-called material events occur relative to your bonds or your issuer, you are required in more real time to report these. And these would be things, I'm not going to go through the whole list, but some of them may be quite obvious. If you've had payment delinquencies or you've defaulted on some of your contractual provisions under bond issues, we're obligated to push that information onto Emma and let the bond market know. Again, so that people in that aftermarket can be making informed decisions. There are some on here that will not be particularly relevant to many of your issuers. A lot of you don't deal with issues that have letters of credit or liquidity providers, and some of these may be a little foreign to you. I wouldn't worry over them much. But things like number 11, rating changes. If you're a bond issuer who has been rated, the rating agencies may change your rating up or down. And regardless of which direction, that is a material event in the eyes of the regulators, and we would be required to post on Emma a notice about our rating change, good news or bad. And you can review the remainder of the list. At that point, I'll conclude my initial comments, turn it over to my colleague.
All right. Good morning. This is James. I get the pleasant task of walking through some of the SEC activities of late. So we'll start with, it has been over the last several years that the SEC has paid more attention to our municipal market. Part of that was with the financial crisis and follow-up with Dodd-Frank. But the bottom line is that we do need to take notice. The SEC is paying attention to the municipal market. So we'll walk through a few of the items here that have taken place in the last couple of years. 2013 was a fairly significant year with the SEC and the municipal market. Penalties against an issuer, falsely stating information to investors about their prior continuing disclosure history, and a clear demonstration that the SEC is willing and able to talk to any issuer regardless of size. We're not just going after states that are issuing or really significant size issuers. You'll see that in a little bit. School districts and kind of the one that everyone has probably heard of is West Clark in southern Indiana, which we'll talk about in a little bit. The most recent action is about a month old, and we'll spend a few minutes talking about this. it's important for several reasons, but Rhode Island issued bonds through an economic development corporation for a loan to a company called 38 Studios. The primary person behind 38 Studios is former Major League Baseball pitcher Curt Schilling, whose number was 38, hence 38 Studios. He was looking to develop a video game and went to Rhode Island, and they negotiated this transaction. As part of the transaction, they needed $75 million to develop the video game. We'll go to the next slide here. So the bonds were then to be repaid by revenues from the video game company. When the transaction was finalized, the bonds were issued. The official statement didn't mention the fact that this company needed $75 million of proceeds to produce the game. It turned out, because of funding a reserve fund, paying capitalized interest over a period of time, that while the bond issue was $75 million, the actual loan and the proceeds available to this company was around $50 million. So because of that, of course, as you'd expect, and that's why we're talking about it, the transaction, the company was not successful developing the video game. They went into default on their loan, and the state of Rhode Island has had to step in. There's been quite a bit of litigation surrounding it, but the SEC is taking their turn as well. And they, on March 7th, filed their information that basically said investors were not fully informed, because while several people knew the company needed $75 million to do this video game, it was clear they were not going to get that through the bond transaction. So the quote there in italics on this slide is probably worth paying attention to. This was the director of the SEC's Enforcement Division, who basically is saying, look, issuers and underwriters need to provide a clear view of the risks involved in the entire project that's being financed. So for this particular transaction, not only was the underwriter charged, and I think they're still debating with the SEC on that front, but two issuer officials were fined personally $25,000 apiece for their participation in this transaction. And it's also important to note that the bonds themselves are not in default. I mean, the state of Rhode Island is still paying the bonds. So the company defaulted on its underlying loan, but the actual investors were continued to get paid by the state of Rhode Island and the guarantee that the state had put behind the transaction. So this shows that it's not just in those situations where a transaction and bondholders are failing to get paid that we need to pay attention to. It's really every transaction and making sure that the entire story is being told. So I'm sure there will be more information as the proceedings continue here. But this was obviously an important and very recent action by the SEC. If we back up a little bit, a couple of years, I'll run through these a little more quickly, but there are still several examples. This one with Harrisburg, the city officials, the financial condition of this city was less than desirable, we'll say it that way. But at the same time, however, public officials were making statements that reached the press that maybe contradicted the actual financial position of the city. And the SEC made note that, look, it's not just what we say in a POS or an OS. If public officials are making statements in the press or otherwise that confuse the issues, that's also going to be a problem. Miami, that was part of an earlier slide as well. Again, some of these circumstances, the SEC would probably say there was a little more active management of trying to conceal some financial issues. But this is another fairly major transaction where former budget director was charged with securities fraud. Well, now we'll talk a little bit about West Clark, which It probably got a lot more press than they or anyone else certainly wanted associated with their transactions. This was the beginning of our favorite four-letter word, MCDC, where Wes Clark said in an offering document that, yep, we've been good with our prior continuing disclosure history, when in fact they had not been as good with their prior continuing disclosure history. So they were brought in front of the SEC along with the underwriter in the transaction, who had not done the necessary diligence in the eyes of the SEC to confirm whether or not that statement in the OS was truthful. And this is where we look to that, again, it doesn't really matter the size of the issuer we're dealing with. So let's talk a little bit about MCDC, which everyone has heard, I'm sure, too much about. At this point in time, through MCDC, we've had 72 underwriter orders where the SEC has settled with underwriters. We have not yet heard of specific communications with issuers, but at a conference about a month ago, folks from the SEC did mention that their goal was to wrap up the entire MCDC initiative in this calendar year. So we fully expect that those issuers that filed under MCDC will hear from the SEC very soon. The next slide is Kings Canyon. I'm going to kind of jump through that a little bit in the interest of time, but it was an additional item kind of at the same time as MCDC. Let's talk a little bit about the underwriter orders and what, if anything, we learned through the 3 separate releases of various settlements with underwriters under the MCDC initiative. The total dollar amount, recall underwriters were subject to fines. Issuers were not subject to fines if they participated. The total dollar amount that the SEC levied against those underwriters was $18 million. So certainly a significant chunk of change. Some of them were on the smaller end, but many underwriters with the various transactions would have hit the ceiling of $500,000. The orders included examples of what the SEC said would be material noncompliance. So we'll get to that. So here were a few, and as you can imagine, with the various different orders of the 72 underwriters, there are some themes we can pick up, and so here are a few. If you failed to just make one filing of an audited financial statement as part of your continuing disclosure, there was an example where an annual filing was 33 days late. Several examples where an item may have been filed on that EMA website in one spot, but it wasn't cross-referenced or linked to different issues. And then also failure to file material event notices if in connection with advanced refundings and defeasances. So through those orders, the SEC has spoken to the industry as to what it believes are items that issuers should be talking about when they're saying, here's my history in the last 5 years of how I have done with my continuing disclosure. A few other things that we learned. If you're silent in your offering document, you don't make that affirmative statement that says, in the past 5 years, we've not failed in any material respect. If you're silent, which is permissible, basically that is the same thing in the SEC's mind as saying you've done a good job. And if you've updated those problems you've had, that's great and should certainly be done, but then you still do have to describe in your offering document those missteps. All right, and so as you hear, so a couple things before I wrap up. One, it's clear via this webinar and for those of you that have spoken to us in the last several months that the entire industry and including your municipal advisors, your underwriters, and of course your counsel is paying a lot more attention to offering documents, the necessity of making sure things are correct, and then also focused on our history of continuing disclosure compliance. And from the underwriter side of the business, through MCDC and their continued regulatory environment, this is not going away. So you'll notice that they are also paying much more attention to an issuer's continuing disclosure history. They're asking questions, confirming whether things are fine or not fine. So it's obviously very important going forward. The last thing I'll say is from that industry conference about a month ago, if you do hear from the SEC that under an MCDC filing, the time frame that they're seeking response is going to be very quick, and if you hear from them that they want to enter into the cease and desist order with your issuer, that's not an invitation to then negotiate. That means they've basically made the determination that what your filing said was a material problem. So again, hopefully you'll reach out to counsel and we'll work through those. Thanks. With that, I'll turn it over to Brian, who is going to walk through policies and procedures that hopefully help us avoid these issues going forward.
All right, well, good morning. John and James have provided a really good overview of the gravity of the obligations of publicly offering bonds, both at the time of the sale and after, and it really does boil down into this concept of primary disclosure, basically what's being offered in the official statement, and secondary disclosure, which is your ongoing disclosure, the continuing disclosure. And so several of you have already adopted continuing disclosure policy, and we've provided this to several issuers that basically addresses three aspects of disclosure. As we said, the primary disclosure, the ongoing disclosure, and third, the policy does discuss how to educate staff and elected officials with respect to these disclosure matters. So we'll walk through all three aspects of this. We'll start with new offerings of bonds and how to prepare an accurate official statement. Now, as John previously mentioned, under federal anti-fraud law, an official statement cannot contain any untrue statement of a material fact or omit to state a material fact necessary to make the statements therein, in light of the circumstances under which they were made, not misleading. That's basically the letter of the law. And you can have an underwriter or a municipal advisor or a law firm assist you in preparing the official statement, but at the end of the day, it's important to recognize that the issuer is who is responsible for the accuracy of the statement. Our disclosure policy provides an Appendix 1 that is basically a 5-step process to ensure the accuracy of providing your official statement. And at this time, we need to introduce the concept of your disclosure officer. And it's up to the issuer who this needs to be. If it should be a city clerk or other finance officer, basically who is usually dealing with the continuing disclosure components, probably run point on this. So at the commencement of a financing, this disclosure officer should develop or cause the finance team to develop a plan for preparing the official statement and schedule it so that there's enough time to complete the work, review the work, and ensure that it's accurate. Basically making sure the other individuals who need to be in the loop are in the loop. And it's, again, the disclosure officer making sure that the process is being properly managed and that they're being assisted by legal or financial professionals as is necessary. And so it's helpful to have an actual system, basically develop boxes that need to be checked on the way to financing, and in fact along the way making sure these boxes are getting checked to ensure all information is available and accurate. Now, step 4, ensuring that any previous failure to comply with continuing disclosure obligations during the prior 5-year period is disclosed in the official statement. This is what James was talking about earlier, and this is kind of the epitome of easier said than done. What needs to happen is you need to look through the previous 5 years, pinpoint the bonds that were outstanding over those 5 years, review what your continuing disclosure obligations were, and then see if they were satisfied by going on EMMA. And maybe the trickiest part of all is determine whether any material events occurred that were not filed or were not timely filed for. This is a process that can be provided by disclosure counsel. It can be provided by a municipal advisor or an underwriter as well. We'll discuss this more later, but this is basically, as James was discussing, the West Clark Community School District or the Kings Canyon Joint Unified School District. This was the issue, that they didn't properly convey their non-compliance, and that's basically what spurs the action. So step 5 is more about timing. The policy dictates that the issuer's governing body shall be given not less than 7 days to review an official statement prior to being asked to vote on its approval, absent extenuating circumstances. And this should be a direction to the elected representatives to contact the disclosure officer for any questions or issues. It basically is demonstrating a scrupulous review. It's protecting against the Rhode Island 38 Studios omission where, while there's actually a fairly material item that's not discussed in the official statement, we need to ensure that there's enough time for the right people to review the official statement and ensure that that information is included. The second of the 3 aspects of our disclosure policy goes to the continuing disclosure compliance. And so we've discussed this before. We've introduced the Emma portal. It's basically a website where these filings are made and where you can actually go to see what filings have been made. Anyone in the public can access it. We basically have distilled it down to 13 pretty specific points of how to ensure that this is up to date and accurate. First, it's important to recognize the overall responsibility for your compliance should fall on the disclosure officer. They should be basically running behind the scenes to be able to recognize what's required and what's being filed in terms of your annual filings, any material event notices, voluntary filings if that is something that's necessary, or other filings required by a particular CDC. The second idea is that before a CDC is even entered into, there needs to be a discussion with bond counsel, underwriter, municipal or financial advisor, basically discussing what the expectation is of the issuer. Before entering into it, you need to recognize, is this realistic? Do you truly understand what it is that you'll be providing? And as we saw in the previous cases that James spoke of, it's important to recognize that not only on Emma, but the statements that are made to the public are accurate. You don't want to go beyond mere puffery. You need it to be actual, accurate statements made in press releases, market notices, and of course, on Emma. Now, to help keep, several issuers do have several issues of bonds outstanding on the public market at a given time, and it can be confusing to keep track of what's required. Oftentimes, not all of the CDCs require the same things, or even the same time frames. And so, on the Appendix 2 of your disclosure policy, you'll see a tracking table, the master tracking table that identifies, as you can see here, the name of the bond issue, date of issue, when the bonds mature so that you know your disclosure obligations are over for them, the identifying information, who should be filing it by means of a dissemination agent, and then a very important time frame, the actual deadline for filing your annual report. And I would say as you have that table, it's good to accompany that table with the appropriate and relevant information for each bond issue, and that would be your official statement. It's available on Emma, the final and executed CDC so that you can readily access what it is that you'll be obligated to update, as well as the dissemination agent agreement so you know who needs to be contacted to get that information filed on Emma. Now, whereas the master tracking table we previously saw shows the undertakings that have been incurred in terms of all the bonds, this tracking table you see before you is more of a per issue showing of when each filing has been satisfied, basically ensuring yourself that the filings have been made here. Basically, you put at the top of it what the issue of bonds are and the basic information for what needs to be filed. As we've said before, the audited financial statements, what tables need to be updated, and any other information that's for each year that the bonds are outstanding. You may find helpful putting in place some form of a tickler system, whether that's on your Outlook calendar, whether that's using the Emma system that provides the actual heads up of when your filing needs to take place. We're looking to do some Emma specific training in the near future for those who are filing on your own, those who may not have engaged a dissemination agent. And we'll shift to the actual time frame for filing. And these numbers that are included are basically default numbers in terms of the time frame when everything should be completed. Each one says at least because it shouldn't really happen any earlier. Kind of go at your comfort level, but I would say at least 30 days prior to the earliest filing deadline, you start getting those wheels turning in terms of, well, what do we need here? Do we need audited financials? Which tables do we need? At that point, you'll probably need to coordinate with perhaps a dissemination agent, a municipal advisor, or someone who can help you provide that information. So at least 10 days prior to the filing deadline, this is a good chance to actually go through with a fine-tooth comb and ensure that the information that you're required to provide is in fact there in your filing. Make sure that you're not missing anything, that the tables align with what were provided in the official statement and what are required in the CDC. And then at that point, about 3 days prior, again, can be much earlier than that, make the filing, whether it's the disclosure officer themselves or it's the dissemination agent who makes the filing. And it's good to actually go on Emma and confirm that, yes, actually all of these filings have been made. It's important to go ahead and do that before the deadline passes for obvious reasons, that once you miss a deadline, you discover, well, this table was missed, then you run into the issue of, well, now in future issues, do we need to disclose that we missed one table? It's a lot easier to find the problem before the deadline has passed. Number 11 speaks to material events or listed events. This is something that John was talking about in the beginning. The time frame here is after a particular listed event occurs. By rule, you are expected to make a filing on Emma within 10 business days of the listed event. I won't go through all of them, and I think John hit on the very important ones as well. Bond calls, if they're material, it's kind of a gray term, but defeasances, if you've actually defeased the bonds via advanced refunding, and rating changes. And in fact, in some circumstances, if your bonds are insured, some of the bond insurance rating changes need to be reported as well. Above all, the disclosure officer should be prepared to be the primary contact person if it's an investor who's got inquiries or other members of the public that has questions about the disclosure or other public dissemination. Then we can discuss here quickly voluntary information filing. If you've decided as an entity that in fact you'd like to go above and beyond what's required by the rule or what's required by your CDC, I'd encourage talking to legal and financial professionals whether that's necessary. But if you determine that to be the case, the disclosure officer is required to do voluntary information filings as well. The last aspect of the disclosure policy is the systematic training of staff and governing body members. And it should not completely fall on the shoulders of this disclosure officer. Everybody should be aware of what's being required through these CDCs. And so the training should fall on employees annually, specific training as needed, and then governing body training on a biannual basis. The annual training the disclosure officer is responsible for scheduling the annual training of issuer employees regarding disclosure and financial reporting requirements of the federal securities laws, including the disclosure policy, Rule 15C212, what material events must be filed, and obligations under securities laws. Now, if this sounds hauntingly familiar, it's because we've been doing that for the past 50 minutes. And in fact, if you feel that you've had enough fun with this and want to share it with your coworkers, there will be a link that will circulate after this. It's all being recorded, and this can help satisfy that annual filing requirement or the annual update. And to basically provide a paper trail that, in fact, yes, this is happening, we've provided here an example of a certificate that says who you are, when the annual training was completed, and that should just go in the file to show that, in fact, this is happening. You're keeping everyone abreast of what's required for continuing disclosure. The specific training, this is sort of an ad hoc when appropriate. You have a new hire that's going to be involved here. Well, they should be trained. This is the sort of information that, unless you're in the business of doing it, why would you know it? So the moment someone is hired, it's important to make sure they're aware of what's required of the entity. Similarly, with governing body training, at least biannually, the disclosure officer should schedule a training session for a governing body for the disclosure policy and what's required to be filed. Turnover on boards or city councils, and also a good refresher to those who are incumbent. It's a good update for them to recognize what's being expected by the SEC. With that, I'll turn it back over to John to discuss some final thoughts here.
Thank you, Brian. A couple of things that we want to emphasize as we wrap up the program. You are beginning to hear more frequently as new bond deals are being done by your issuers. At least us and other professionals talking in terms of a bond counsel role and a disclosure counsel role on deals that are going out into the municipal bond market. We've wanted to take this opportunity to try to help clarify what's meant by those terms and what the functionalities are for the two different roles. Both of these terms refer to lawyers who would represent your issuer on the transaction. So, for example, the voices that you've heard today, we're all bond lawyers, and we, with some regularity, will get hired to serve as both bond counsel and disclosure counsel to a governmental borrower on a particular bond issue. Well, bond counsel, that's the traditional role that you're quite used by this point, if you've been doing bond deals for a while for your issuer, to having the lawyers perform. We look into state law related compliance issues. What hoops do we have to jump to get authority to issue the debt? We look at federal tax exemption issues, because whenever possible, everybody wants to be able to do cheaper interest rate tax exempt bonds. And in addition, bond counsel is traditionally expected to be the preparer of most of the city council or board of supervisors or board of directors proceedings, the actual bond documents and loan agreements and certificates, including that CDC that we've talked about, continuing disclosure certificate, that's come up frequently in this conversation. Well, the disclosure counsel role is related but not identical. Disclosure counsel would be hiring a lawyer to represent your issuer to protect the issuer's interests with respect to that preliminary official statement and to examine regulatory compliance issues in this arena of both pre-sale disclosure and helping folks to get off to a good start with respect to continuing disclosure. As disclosure counsel, we'll help to conduct due diligence review of your past continuing disclosure compliance or a little bit of non-compliance, as the case might be, and to make sure that those issues that may be discovered are being dealt with adequately. In addition, as disclosure counsel, we are regularly asked to deliver what would be called a 10b-5 opinion, which is a legal opinion that we, as the lawyer, write to our client, the issuer, basically providing cover and saying, yes, that the regulatory issues under this rule have been complied with. And with the issuer's permission, we typically will issue what's called a reliance letter so that the underwriter, your investment banker, can also rely on our legal opinion. This is important because in many instances we're finding that it helps to ensure underwriter participation in the deal and potentially to make your bonds more saleable. Now, as we wrap up, there's a few just basic takeaways that we hope you'll keep in mind. First, our responsibilities with respect to disclosure do not end at closing of a bond deal. Now, certainly, we've got a lot of responsibilities, as we pointed out today, before closing. We've got to make sure that that preliminary official statement is a truthful and accurate document, that it's not fraudulent, doesn't have any material misstatements, and that it gives the bondholders or potential bondholders an opportunity to review our issuer's financial position, the nature of the bond issue being offered, and any material risks that they might face. We've got loads of responsibilities before closing, but they don't end there. Continuing disclosure is just as important and needs to be attended to. These post-issuance requirements include the annual report filings to EMMA that we've discussed, and keeping an eye out for spotting those material events that might happen and making sure that those are disclosed onto EMMA. The regulators are serious about post-issuance compliance. We're convinced that this is going to continue to be a more heavily regulated issue, and so it is important to adopt and follow the types of policies and procedures for federal disclosure compliance of the like that we've shared with you today. James, have we had any questions come in on the emails that we might want to try to hit in the minute or two we have left?
Yeah, so one question is, what does an issuer need to do if they've not adopted policies but want them in place? And then also how would that go about with training counsel or governing body?
Did you want to field it?
Yeah, so what we'd first do is reach out to your normal contact here at Dorsey, and then we can provide the policies that would be adopted along with the resolution that would go with those policies. And then to the extent it's helpful, we're certainly always willing to discuss or be available for council or board meetings to walk through any questions on those policies before they're adopted, and then help with the training after they are adopted as well. And we can fine-tune the policies for any particular issuer if there are things that, as you're reviewing them, just maybe don't quite work or don't make sense for your issuer.
I think that's probably about all that we have time for if we're going to wrap up on time. I do want to encourage all of you to please not be shy about any ongoing questions that may arise in this arena. We are available to you. You can see on the contact information slide email addresses and a main phone number for our contact information. You're welcome to reach out to anyone on our team if you've got any issues that you wish to discuss. I will also make the offer, if any of you need some form of a letter verifying your participation in this program, we're happy to provide that. And you could direct that sort of request to either me, John Danos, or to James Smith, and we'll make sure that we get something out verifying your participation. Thank you for participating in our program. We look forward to talking with all of you soon.